expert views on the today's topic, the Forensic.India would like to thank Nelson Mandela University, South Africa, for believing in our work and collaborating with us. The Forensic.India is highly grateful to the university. Now, the conference is carried forward by the introduction of our today's keynote speakers who are pioneers of their field. Our first expert, the keynote speaker is Ms. Desiree David. She is a lecturer in the Department of Criminal and Procedural Law, Nelson Mandela University, South Africa. She is also attorney of the High Court of South Africa. Now I request Ms. David ma'am to start the conference by sharing her expertise or views on the concerned topic.
Thank you very much for that introduction. And thank you very much to Forensic.India for inviting me to collaborate with them on this conference. So, as it was already mentioned, I'm an attorney of the High Court of South Africa. And at present, I'm a lecturer in the Department of Criminal and Procedural Law at the Nelson Mandela University in Port Elizabeth, South Africa. My areas of expertise are in the law of evidence, in forensic evidence, which I teach to the undergraduate LLB students. And then I'm also involved in legal practice and other practical and mentorship initiatives in the law faculty. I also teach in the master's program, in our criminal justice master's program, in the advanced law of criminal procedure and evidence. In addition to that, I do a lot of cross-faculty teaching, specifically with the health sciences department. And so I teach law to the paramedics, to the nurses, to the dietetics students, and I also do some work with medical doctors and pathologists, specifically with regard to the issue of testifying in court proceedings to explain to expert witnesses exactly what happens during the trial process, specifically in criminal trials, and what to expect from, or what is expected of an expert witness in criminal trial procedures. So, yeah, that is some of my experience with regard to the Faculty of Law. And then I also work with the Law Society of South Africa with in our PVT program, that is our post-LB pre-admission to the legal profession, as well as being on the board of directors of the South African Medical Legal Association. So just to give you some kind of background of my experience and my expertise, but predominantly I'm a lawyer at heart. So one of the things that is very important to understand, both for law students and for students in the field of forensics, irrespective of what specific area of specialization you're involved in, is that more and more in cases that are becoming before the court, it is becoming necessary to rely on the expert testimony of witnesses who are specialists in their field of study or in the field in which they practice. And very often you find, and we've seen this in South Africa as well over the past many years, that there is an increasing reliance on the use of expert witnesses because of the increasing amount of forensic evidence that is being presented in court proceedings. whether it is in the form of a doctor who's examined a rape victim and may have to testify about his findings, to a pathologist who's now having to establish the cause of death, manner of death in a murder investigation, um, um, to things like ballistics and toxicology. You must remember in South Africa, we have a very high incidence of violent crime, gun crime, knife crime. We have a very high rate of murder. We have a very high rate of rape, sex crimes, and so on. And so when these cases are prosecuted, you find quite often there is a reliance on some kind of forensic evidence in the form of DNA, in the form of ballistics, blood spatter, and so on. And so it becomes necessary more and more for experts in the different categories or in the different fields to bring their expertise to court in order to assist and participate in the criminal process. So, in when a matter goes to court, if a matter goes to trial, whether you are dealing with a civil matter or a criminal matter. With the civil matter, obviously the matter goes to a court because the parties themselves can't reach a resolution on their own. So this may be a kind of situation if you're dealing with a civil case where there's not necessarily a crime that has been committed, but you have two individuals who very simply have some kind of an issue with each other, and they cannot between themselves resolve the issue that they have with each other. And so they have to approach a court in order to resolve that dispute for them, to give them a judgment or to give a decision in that particular case. So this may be a situation where we are looking at, let's say, a family member has died, a father or a grandfather has died, and he has in his will directed that his estate is going to be divided between three of his children that he's named. And maybe he has a fourth child, and the fourth child thinks that my father would never have left me out of the will. This signature must be forged, and therefore I want the court to decide whether this will is a valid will or whether this will is invalid, and it will have repercussions for then whether the fourth child would be able to inherit. So what the issue there is whether the signature on the will is a forgery or whether it really is the signature of the grandfather, the testator in that situation. So this would be an example of where you would require a handwriting expert, for example, to examine the document, to examine the will, to examine that particular signature that we know is an authentic signature, that the deceased person has signed on some other document. And then he's going to have to indicate to the court, based on his examination of the document and having recourse to his experience and his expertise in the field of handwriting, to be able to say why he thinks it's a forgery, why he thinks it's a legitimate signature, and give reasons for that. And when he does that in court proceedings, the presiding officer obviously is guided by his findings because he has the kind of expertise that the judge, the presiding officer, does not necessarily have in that particular field. So the judge is an expert in legal matters, but on the specific issue of handwriting, you would require somebody who's an expert in that field to provide some kind of guidance to the presiding officer, the judge, in order for him to consider this with all the other evidence and make a decision as to whether this was a forgery or not. And obviously in a criminal matter where someone has committed a crime, where a person's conduct falls within the definition of what is criminal conduct and has led to the commission of a crime, then of course the state puts into effect the mechanisms that are necessary in order to prosecute him and in order for justice to be done in that kind of situation. Now, in South Africa, and I speak from the point of view or against the background of the South African legal system. I think there's, from what I understand, there are quite a few similarities between the legal system in South Africa, especially when it comes to the law of evidence and you guys in India. Just if you think about the history of our two countries and so on. We have an adversarial system. We don't have a jury system in South Africa. So the presiding officer, the judge or the magistrate, is the person who makes the final decision, but it is an adversarial system of justice. With an adversarial system, you're looking at the kind of situation where the whole trial process can be viewed as a kind of a battle or a kind of war between both the parties, between the state and between the accused. And the adversarial system is very much a win at all costs kind of system. So what I mean by that is that when presenting their cases and when deciding what evidence to put forward to the court, the parties enter it as though they were entering a battle. And in this kind of system, there's always a winner and a loser. And of course, everybody wants to be a winner. And whether you win or not will depend on how good the evidence is to support your case or to support the up in the event that you are acting for an accused person in that kind of situation. And the evidence that you are using in order to win this battle is the weapons. So the weapons that you are using in this whole adversarial system are the different pieces of evidence that you are going to be presenting. So the witnesses in general are responsible for presenting the evidence to the court. So you have a number of different types of evidence. You have physical evidence, and this may be, for example, in a murder case, it would be the gun that was used to shoot the person, or it would be a piece of clothing that was found at the scene of crime, or some kind of trace evidence that was found on the body of the victim, like semen or hair, or some kind of fibers that were found on the body of the victim. And so these would be pieces of physical evidence that you would have. Now, even though you have physical evidence, you're going to have somebody who's going to testify about that physical evidence. In other words, where it was found, what is its significance, if there were tests done, what are the outcomes of those particular tests, and so on. You can also have eyewitness testimony. And eyewitness testimony, unfortunately, has proven to be notoriously unreliable. We've seen in a number of cases, for example, if you are familiar with the Innocence Project in America, and there are chapters of the Innocence Project in many different jurisdictions around the world. One of the things that they do is that they examine or they have DNA tests done post-conviction in order to ascertain whether those convictions were correctly done. In a lot of cases, prior to the use of DNA evidence, or when DNA testing was not that widely available, in a lot of cases, you find convicted persons were convicted solely on the eyewitness testimony of the complainant, of the victim. And in a number of cases, subsequent DNA testing has proven that the accused could not necessarily have committed those, let's say, rapes, because these were a lot of the cases where there has been exonerations. And I don't like her. She's a horrible person. And so, just to give you an illustration of um, why opinion evidence generally is not admissible. We have taken a lot of although South African law has its source predominantly in Roman Dutch law. The law of evidence we have taken from English law. So a lot of our principles in the law of evidence are similar to or the same as the English law principles with regard to um, um, the specific rules of evidence. So the opinion evidence generally of a layperson is not admissible. But when you come to an expert witness, what makes the expert witness testimony relevant, even though it's just the expert's opinion, is the fact that the expert who gives testimony has has a lot of knowledge and expertise and experience in that particular field. So if you are calling a ballistics expert to testify as an expert in court proceedings, okay, his opinion matters and his opinion is relevant because he's not pulling things out of the air. He has a certain academic qualifications. He has certain professional qualifications. He has a certain amount of expertise, experience in his particular field. He is viewed as an expert by his peers in that particular field. And so based on his knowledge, his skill, his expertise, his experience, and so on, that qualifies him to give an opinion which is based or which is founded in his experience and expertise. And that is why the opinion evidence of an expert witness is admissible in court proceedings. Obviously, when you are dealing with an expert witness, the expert that you have chosen to testify in these proceedings must be an expert in the field in which he is going to testify. So you can't have a ballistics expert, for example, testify about DNA. Those are two completely different fields. The fact that somebody is is an expert in the field of DNA does not mean that his expertise can extend into the field of ballistics. You're going to have to find a ballistics expert to testify in that particular field. When an expert is called to testify in court proceedings, the presiding officer has got to be satisfied that the expert witness that you are calling is in fact an expert in the field in which he is called to testify. If he is such an expert, then his testimony will be relevant and therefore it will be admissible. So with all evidence that you are dealing with, the evidence only becomes admissible if it is relevant to the court proceedings, and obviously if it's not excluded by some other rule of evidence that may be applicable. So in order for you to have someone sworn in or have someone accepted by the presiding officer as being an expert witness and being able to testify, his testimony must be relevant to an issue before the court. And if you remember why we are using an expert to testify, it's because an expert has the kind of expert knowledge and skill and so on that the presiding officer does not have in this very specific field. And here, you'd normally use expert witnesses in the field of toxicology, pathology, anthropology, ballistics, blood spatter, um, in accounting, um, and so on. So they're very, very specific, highly scientific, require specified knowledge and so on. And so you would have to have your expert in that particular field. Now, in order for your expert to be able to testify, he's got to be an expert, as we've mentioned. So he's got to have the requisite academic qualifications, as well as practical skill and expertise. So it's not sufficient for somebody to have a string of, 5 degrees and have not done any practical work, because the bookwork alone does not necessarily qualify you as an expert witness. So your academic qualifications have got to be supplemented with professional qualifications, with practical experience in that particular field, and so on. So some form of hands-on, some form of practical experience is also required. If you are thinking about, in your field, you'll be viewed as being a novice if you've got no practical experience. Okay, so if you've got no professional, no practical experience, you can't actually put yourself out as an expert because you're still very much a novice in that particular field. Um, you sort of progress to being a beginner in your field. I would say if you are in a position to note recurrent, meaningful situational components, and so on, you move up then to being competent, and the competent person is someone who's now beginning to understand actions in terms of longer range goals within that particular field. You become proficient. I think if you are able to perceive situations as a whole, rather than looking at them in a very piecemeal, or looking at them in terms of the very specific aspects. And you'll understand why it's important for you to actually be an expert rather than just novice, beginner, competent, or proficient. Because as an expert, it's required that you have some kind of intuitive grasp of the situation. Because remember, you're going to have to be assisting the presiding officer, who's a layperson in that particular field. So an expert is expected to have some kind of, or to have an intuitive grasp of the situation, who is able to look at the problem or look at the dilemma that is being faced, and who's able to zero in on the accurate region of the problem, to be able to analyze the data or analyze the information, and based then on their expertise and knowledge and so on, come to a particular conclusion. Although it is an opinion, it's an opinion, the conclusion that is an opinion that is based on examining the facts, identifying the issues, being able to apply the rules of the scientific field that you are in order to come to a conclusion that is going to assist the presiding officer to understand why is it that you've concluded that the gun had to be fired from the first floor and not from the second floor window, as the prosecution is claiming, for example. Okay, so that can come, you're not just pulling it out of the air, but you're explaining in a lot of detail, and you are giving reasons to the presiding officer as to why you think it's one scenario as opposed to something else that one of the parties is putting forth before the court. So in order to be classified as an expert, and therefore to have your testimony be admissible in court proceedings, the discipline in which the expert is testifying on, it must be an expert discipline. It must be something that is recognized as being an expert discipline that requires the testimony of an expert. Like I said, it's not sufficient that the witness is just a practitioner of an expert discipline. He also has to be an expert. So in addition to being part of or belonging to that expert discipline, the practitioner also has to be an expert in that particular discipline. Um, and, you know, depending on the kind of issues that need to be where experts are required. Sometimes you may have a situation where somebody just has the book knowledge, so has just studied and does not have any practical experience or exposure to the practicalities of that particular field. And as I've told you, in that kind of situation, he won't be considered an expert because there's still he hasn't necessarily immersed himself in the practice of that particular field. But you may have situations that arise where somebody may not be as highly qualified with regard to the number of degrees, or may not even have any formal qualifications. But because of the time and his practical exposure, in other words, he's had practice in that particular field, he may then, by virtue of his practical knowledge and his practical expertise, be considered to be an expert. But very much dependent on the facts and circumstances of each case and what it is that the person is going to be called to testify on. So, like in South Africa, for example, um, in with of people in South Africa, there are certain rituals that have to be performed, which requires the young men to undergo circumcision as a rite of passage into manhood. Now, you can't study for that. There's not a degree, but there are certain well-respected elders in the community or persons in the community who have been passed, who the knowledge has been passed down from generation to generation. They're involved in these rituals, and unfortunately, in the past few years, there have been a lot of cases where a lot of young men are dying because of botched procedures or incorrectly performed procedures and so on. And so you may have then, in order for a court to find out whether there was negligence or whether it was just recklessness or gross wrongdoing involved, you may require someone to testify about what the correct procedure is in this kind of situation. So even though you don't have someone who has a tertiary qualification, for example, you may have someone who's been considered by the communities and so on to be an expert or to have all the necessary knowledge that obviously in this case has been passed on from generation to generation. And so that may be a situation where that person, even though he does not have a formal qualification, may be accepted by the court as being an expert in that particular field. And then when the expert is testifying, the expert has got to testify about matters that are covered by his discipline. In other words, he mustn't stray out of the field of his discipline where his expertise is. And the testimony he gives must be directly relevant to the issues at hand. So in giving the testimony, the expert must make very sure that what he's testifying about is or falls within his particular field of expertise. I've said this a few times before, but I'm going to reiterate. When an expert has to testify or is called to testify in court proceedings, even though he's called by one party or the other, okay, the duty of the expert is to assist the court. And whenever an expert is testifying in court proceedings, he must not display or should not display any bias to one party or the other. because his whole job or his whole function in the court case is to assist the court. So even though he's called either by the prosecution or by the accused, by the defense, ultimately, obviously, and they're paying his fees, his function should not be, or the manner in which he testifies should not be influenced by the party who is paying him, by the party who has called him as a witness, because ultimately his duty is to the court. In other words, he's only there testifying, he's only giving his opinion in court proceedings because the judge is a layperson with regard to that specific aspect that the expert has been called to testify on. So, for example, ballistics. The judge is a layperson when it comes to ballistics. We have an expert who's an expert in ballistics. His testimony can assist the presiding officer, the judge, in those issues that the judge has only a layperson's knowledge. And so that is his function. Now, this is a controversial aspect of an expert testifying, because very often in my classes, when I deal with this, the students will say to me, "But ma'am, why are you going to be wasting money calling an expert if you know he's not going to testify um, about something that is favorable to your case?" And my response to that is, if you're calling an expert, and I think what we need to remember is that the manner that you present your case is very much up to the parties or the legal representatives of the different parties. So the legal representatives are deciding from a strategic and a tactical point of view how they're going to present their case, how they are going to use the evidence that is most going to benefit their case. And obviously, if you are deciding to use an expert, your expert is not going to come across as being very professional if he is biased towards one side. Obviously, you're not going to use an expert who is going to make the opposition's case for them. Okay, so you may just decide that if the expert's testimony is going to do too much damage to your side of the case, we're not going to use an expert, because you're not compelled to use an expert. The person or who you call as a witness very much depends on the party that is preparing and presenting the case. So you may decide that you choose not to use an expert. You may decide that you want to use 5 experts. The option is up to the legal representative that is doing that. But once you have a situation where you've decided to use an expert, then it's very, very important, and especially if you are preparing your expert, and this is something for expert witnesses to understand as well. Even though you are being called by one party, your ultimate duty is not to the party that calls you, but is to the court. So the ultimate duty is to make sure that you give an opinion based on your knowledge, your expertise, and so on, to the extent that it correctly reflects the science, that it's been well reasoned, that you've taken all aspects of the matter into consideration when you have given your decision. And that is why it's so important when an expert is testifying that the expert is able to give reasons for his decision. Remember that the presiding officer, the judge or the magistrate, is not forced to follow the opinion of the expert witness. The opinion of the expert witness is treated like the opinion of, like the evidence of everybody else, in that the evidence then is evaluated by the judge with all the other evidence that has been presented. So even though the expert witness testifies, when the expert's testimony is weighed against the testimony of other witnesses and weighed against the other evidence, the presiding officer may decide to place very little weight on the expert's evidence, and therefore in the evaluation it does not carry very much weight when it comes to the overall finding in that case. So the presiding officer still has the discretion whether he is going to rely on the expert's evidence or not, and whether he does this by evaluating or weighing up the expert's evidence against the evidence, against all the other evidence that has been led in that particular case. So the duty to be impartial by the expert is very, very, very important, because that duty is the duty that the expert witness um, owes the court. And at the end of the day, the duty of the expert to the court overrides any loyalty that the expert may have to the person who is paying his fees. In a perfect world, this would all happen. Unfortunately, sometimes you have a situation where expert witnesses may not necessarily or may be caught up in the whole thing of testifying for one party, and you may have issues. So a couple of years ago, about 2 or 3 years ago, we had a very high profile case in South Africa. And this very highly respected, well-to-do businessman was accused of killing his wife. He maintained that she had killed herself. So what had happened was that he'd been having an affair with a colleague of his. His wife found out about it and basically put a stop to that affair. But unbeknownst to the wife, the affair didn't stop. And there was some work function that everybody had to attend, and the wife saw the husband and the girlfriend. Well, I suppose she saw sparks fly, and she realized that this thing was not over yet. So they went back to the room and they had a bit of a fight. And the next thing that happened was the husband calls out to the security guard to say that his wife committed suicide. His theory was that he walked into the room. They had had a fight, and he'd gone out to get some air, and he walked into the room and he found her hanging by her the belt of her dressing gown from the back of the bathroom door. And he said he removed her from there, by which time he saw that she was dead, and he went and called the security guard. Um, Examination of the crime scene showed that she had some injuries on her face, which it was then found out were more consistent with having been smothered by a pillow than hanging herself, because when the pathologist conducted the autopsy, um, the um, uh, the findings were not lining up with the husband's version of she hanged herself and then I cut her down and brought her into the room. The idea was that he smothered her with a pillow, and he was wearing a ring, and that ring left little injuries on her face. He argued that she'd hurt herself some other time, but with the age of the injuries and so on, that didn't um, seem to be logical. And after smothering her, he staged the scene so that he could give himself an out by saying that she had killed herself. And a very well-respected, high-profile pathologist testified on behalf of the accused. And this is a person who had a very good reputation in South Africa. In fact, there were a few projects that he was involved with that I was involved with as well. And, it was somebody that we knew. But what happened during the course of his testimony and when he was cross-examined is that the presiding officer concluded that he was very, very biased in favor of the accused, because even when in cross-examination, there was certain information put to him where he should have made concessions. He failed to do so because he was obviously so very partisan and so very much acting almost as an advocate for the accused, that where he should have made certain concessions with regard to some of the findings, he failed to do so. And the presiding officer was highly critical about him in that situation. So one of the things Tara, the speaker tomorrow, will talk about is the fact that it is so important when you are testifying as an expert witness that if there are concessions that need to be made, don't come across, you make those concessions where necessary and where, you know, um, the facts are such that you should make those concessions. Because failing to do so, just sticking to your guns no matter what, um, basically says to the presiding officer that this person is biased in favor of one party to the extent that he's not prepared to consider another alternative or to even give it credence in that situation. Remember when I talked about the presiding officer or the judge evaluating the evidence? That then goes to the reliability of the witness. So what the judge is going to find in that is that the expert witness is not a reliable witness because he's not willing to see another possibility. He's not willing to concede. He's not willing to um, make concessions and so on. And then the judge will question how reliable is this person if if he's so adamant and so stubborn about the way he's seeing things that is not prepared to look at anything else. So those are some things that an expert witness needs to consider when he's testifying in court proceedings. Ultimately, as I've said, his testimony, his opinion is there to assist the judge to be able to help the judge to form his own independent opinion based on all the evidence that he's heard, including the expert witnesses' um, um, testimony. And obviously, if the expert testifies in a matter where his scientific opinion that he gives is based on sound scientific principles, where he's carefully considered all the surrounding circumstances, the surrounding information, where his conclusions are intelligent, are convincing, where they have been tested or they meet the rigorous standards as required by that profession or that field of forensics, then it becomes a very, very important factor for the court to consider. And the court or the presiding officer clearly must take that into consideration when he's making his decision. So ultimately, as even though the expert witness is an expert in that particular field, at the end of the day, the final decision is made by the presiding officer, it's made by the judge, but the expert witness assists the court. So the expert witness needs to make sure that he's not biased, that he's very, very objective, that he does not omit or leave out facts that could necessarily be prejudicial to his case, and also with regard to preparing yourself to testify, it's very, very important that you are properly prepared. You don't want to have a situation where we have this in our city a couple of years ago. Um, a guy was involved in a motor vehicle collision and a young student at our university was killed. And he had a whole string of charges against him, but there was a drunk driving charge because he was allegedly under the influence of alcohol at the time of the collision. And what happened in this case was that the test that was used to draw his blood in order for the blood alcohol level to be tested, that was expired. There's a little expiry date on that vial that you draw the blood in. So that was expired. And the whole question before the court was whether the results of that test were um, were admissible, seeing as how the protocols were not followed in that they used an expired test. And one of the questions, that should have, that possibly the prosecution could have asked in re-examination was whether the expiration date affected the efficacy of the test. In other words, the fact that there was an expiration date, did it have any influence on the findings of the blood alcohol level? And if that witness had properly been prepared, there's a lot of literature and so on that says that it doesn't necessarily affect the preservative and the anticoagulant in that test. It does not have an effect of the readings. But that witness was not properly prepared, and the prosecutor was not properly prepared. So he was not in a position to rehabilitate his witness by talking about that. They just left it as, oh, it's expired. Whereas they could have said, it's expired, but in your expert opinion, does that affect the findings? And maybe a court would have decided differently had they addressed that particular issue. But at the end of the day, the accused was found not guilty because the entire case rested on whether he was over the official blood alcohol limit. And because the test was ruled to be inadmissible, that was an issue. So preparing your witness is obviously very, very important when you come to dealing with an expert witness. So I'm going to stop here. It's obviously, there's a lot more interesting cases that I could tell you about, and maybe Tara will include those, some cases in tomorrow's session. But this is just a general overview on the expert witness and what is expected from the expert witness when you testify in court proceedings. I thank you for your attention. I don't know if there are questions that you have.
हेलो अभी तक आया नहीं आवाज कुछ
आपने तो बोला नेक्स्ट अनाउंस करेंगे या नहीं करेंगे देखो अभी क्या करना
Yes, sir. Please start your presentation, sir.
who's this Atul? Hello, can you hear me? Can you hear me? Hello, can you hear me? Hello, hello Atul, can you hear me?
Yes, sir.
Yeah, can I start my presentation? Hello,
आपकी आवाज आ रही है
Yeah.
can you hear me, sir?
Hello.
Yeah, can you hear me?
Yes, sir. Yes, sir. Yes, sir. You
Can I-
can start.
Okay, so should I start now? Just give me a signal when should I start.
Yes, sir. Yes, sir.
Yeah.
Start.
Am I visible?
Yes, sir.
Am I audible?
Yes, sir. Yes, sir.
Is it the right time to start? Hello.
I yes, sir. Yes, sir.
मैं शुरू कर दूं ना? Hello. Hello.
Yes, sir. You can start.
All right. My name is Charanjit Chandrapal. Okay. Hello. I am today speaking on expert opinion in law, with specific reference to the law that about a number of courts in the last 20 odd years which I have garnered. I would like to share some of my insights into when and where expert opinion and expert evidence would be used in law. We have in India a system of law which is adopted from the English common law when the Britishers were a part and parcel of this continent in the lawmaking process. At that time, there was an act known as the Indian Evidence Act evolved. The evidence law governs both civil as well as criminal law. Evidence Act is also used in laws like Income Tax Act. However, in India, as per Section 2 and Section 3 of the Evidence Act, for quasi-judicial authorities, the evidence law may not be applicable. With this picture in mind, we first analyze under which section of the evidence law that expert evidence and expert opinion come into play. The expert opinion comes into play under section 45 of the Evidence Act of 1872. Now, what does expert of evidence mean, expert opinion mean as per the Indian law? We may first realize that when an expert is called, first we will segment the laws under which an expert evidence and an expert opinion may be used and to what extent it is to be used. First, we will take in hand the criminal law, because expert evidence is called upon in criminal law in a number of cases. Expert evidence in criminal law comes into play primarily in cases where the role of an opinion is required. I again mean opinion. Opinion does not mean that it is binding on the court. Time and again, the Supreme Court of India, as well as the various high courts, have specifically and categorically stated that expert opinion is all dependent on the circumstances per se. Not only circumstances per se, it also depends on it also depends on the nitty-gritties of each matter, the circumstances prevailing in each matter. For example, when a document in question is supposed to be forged, the first thing that a common man may think that we will send it for an expert opinion handwriting analysis. That is the, very sorry to say, the stupidity even of the police department. Without analyzing the situation, just send it for expert opinion as a matter of a ritual. This kind of an approach would be, I mean, disastrous. I was once giving a lecture to the economic offences wing of the Mumbai police that expert opinion may not be required in a number of cases. Many a times the documents are registered before the sub-registrar. The agreement is registered before the sub-registrar. Now in such a case, how is expert opinion going to help? Nothing. The document still can be a forged document. The definition of forgery under 463 of the Indian Penal Code would mean that a document which is false. A false document need not have only forged signatures. Copying a signature is only a part or a way of committing forgery. It is not the only thing that will tantamount to forgery. A document evidencing that a particular document is false and a transaction is true when the transaction is not actually taken place. It's a fuzzy. It's a fuzzy in Indian language means it's a false transaction. A transaction which has not taken place at all. And still a document is generated, even that is forgery. In such a case, how would expert opinion help? How would signature verification help? Another important aspect which the departments, the state departments forget is that in expert opinion, they seldom approach the bankers who have seen the signatures, the actual signatures of the person. They don't do it. They simply take up the document and send it to the handwriting expert. And handwriting expert again has its own limitations. The exact person in the case of a forgery of a check, or in the case of a forgery of a will, or in the case of a trade transaction, would be number one, the person himself who has seen the document. And in case the person is dead or is not available, then the banker, because the banker sees the signature of the person who signs a check almost on an everyday basis. Then there would be a trader who's used to, or a person who is used to seeing the person's signature on a day-to-day basis when he's accepting and taking the documents. These kind of opinions matter more to my knowledge in the case of a forgery. Now, in very delicate cases of forgery, where the forger has used a very good technique, a very good tactic for forging the signatures. There, yes, when there are two opinions or two or three opinions, then expert opinion would definitely matter as to what is the expert opinion saying about a particular signature. Then, after the expert opinion, the document itself, whether the document signifies that there was any need to commit forgery. For example, in a case which I have encountered at a personal level, a criminal who had become an advocate, I'm not naming him, he was in the habit of creating false documents. And then when the victim would take him to court, he would himself say that he has not signed those documents, have an FIR registered, and trouble not only the victim, trouble the victim's advocate also. And finally, when the report was filed by the police came to a conclusion that the transaction has actually taken place. The transaction taken place is of a particular nature which could not have been called forgery, because this is an actual transaction which took place. A person cannot say that he has not signed. Then another angle in case of documents which are basically regarded as forgery is the way in which the transaction has been actually done, supported by the banker's book evidence. When the banker's book evidence shows, meaning the bank statements show, that a particular money had come in an account, and finally on the same day it was taken away from that account, or a cash of a very big amount was lodged in an account and then it was taken away from another account, it would show that the transaction was bogus. In this case also, a forgery would be maintainable and mere matching of signatures would not be maintainable. Another example would be where a person has signed blank checks or a person has signed blank receipts, and then a person simply computerizes something or types something and puts something on the blank receipt or on the blank check and presents it for payment or uses it as a document knowing it to be false. Even that is forgery. Forgery, the definition of forgery has got a very big ambit. Forgery means a creation of a false document. That's all. Now, coming to this is one aspect of expert evidence where expert opinion, where handwriting expert's opinion may matter. Handwriting opinion, again, there are private handwriting experts, then there are public handwriting experts. Courts usually play more emphasis on the public handwriting expert, but there is no bar that a private handwriting expert and a public handwriting expert's opinion is placed before the court. Finally, there are plenty of judgments which go on to say that in a particular circumstances, having regard to the facts and circumstances of the case and having regard to the transaction, the merit of the transaction which has taken place, whether a document would be regarded as forged or not. Now, Coming to another set of documents, which would be like a will. In a will, usually there are two ways of analyzing evidence, and the role of an expert comes into play more in the criminal law. A case for cancellation or a case for regarding the will as null and void can be made out in the civil law, and a case for penalizing a person for committing forgery may be made out at criminal law. In criminal law, the tenets of viewing a document are a little different than what it is in civil law. In civil law, a lot of emphasis is paid on the documentation pre and post the transaction, or what has actually happened. In criminal law, one goes by a very strict magnified lens as to whether all circumstances lead to the conclusion that the document is forged. Now, when we see a will, we have to first see that the will has witnesses. If the witnesses are authentic, if they are of genuine character, of people of very good standing, then in that case, to call a document as forged may be regarded as very, very difficult because the person is dead. Then we see the signature. The signature, it may be remembered, with every 5 or 6 years elder that you get, the nerves of your hand in which you write the document, those nerves loosen in pressure. A writing made after 5 years would be quite different than what it was 5 years before. Unless, of course, the person is of an exemplary good willpower. Then his handwriting may change not much. A person who is sick again may have a vibration kind of a handwriting, which will be discerned from the medical report as well as from the signature. So these factors go in the opinion of formation of whether a signature has been forged. Secondly, the handwriting expert or the forgery expert, he will play emphasis on certain aspects. For instance, the way you write C. There's a method of writing C. And the way you number yourself, or the way you put your dot. And those aspects are very fine. Even if a person's handwriting becomes loose, the pattern of writing will not change. The gaps, yes, may be a little different. I'm doing this because I have encountered a number of forgery cases. Allegations made on lawyers, allegations made on the notary public, allegations made on various people. And when the expert opinion comes into picture, the court sometimes rejects the expert opinion because in the form of other evidences, the transaction seems to be genuine. So in such kind of cases, where all other intrinsic evidences lead to the fact that yes, a certain thing has occurred or a certain aspect is proper, there the court may not go into the formation or taking into account of an expert opinion. An expert opinion would matter in cases of forgery where there are 2 or 3 opinions possible and which lead to a conclusion that yes, a forgery would have committed or would have given a huge benefit to some kind of a person. That is when an expert opinion would matter. Now coming to another aspect of forgery, I'm taking a little more time of forgery because I have number of false cases which are done in court, which actually waste time of the court come up. In number of cases we have seen in court that sometimes clients who are living in far off places who can't come in the court for signing, they go to the notary in that area and get a signature done and send the document by post, and that document is filed. And then sometimes when the order now is not in their favor, the client would come and say, no, this was not my sign. Then what the court does? The court actually analyzes number of other things as to whether the client was aware and whether the client has particularly done a particular signature or an exercise. And in that case, the court does not go into the aspect of forgery, because in our criminal procedure code, there is a particular section known as section 195 read with section 340 pertaining to forgery in court proceedings. It all depends on the court as to whether such kind of allegations where the client has himself given permission to somebody to sign on his behalf. In such kind of cases, the court doesn't even call for an expert opinion, sees the entire proceeding and whether any kind of effect of such a kind of a blatant denial later after taking benefits in terms of favorable orders previously from the court occurs. In these cases, expert opinion is not even called. That ends the subject of forgery. Now we come to another aspect of criminal law, where which I find often is abused in the court of law. An expert opinion of a person who has used the rifle, has used the barrel, or has used a double barrel gun or a single barrel gun, or has used a particular knife. These kind of cases which are unnecessarily embroiled in technicality in the courts of law. When these kind of cases come up in the courts of law, at the time of examination and cross-examination of the expert, emphasis which the court pays upon is whether the person who's giving, whether the expert who is giving that opinion is, number one, qualified to give an opinion, his standing and experience, and three is the quality of the opinion that he has given. Example, in 1989, not naming the client, since I knew the client and I had refused to take his case. In 1989, there was a group of people who came to one of my client's place, whose cases I took in some other matters, not in this particular matter, to recover some money from him. In a fit of rage, the person who were to recover threatened the client, and in a fit of rage, this client of mine, he took out his licensed revolver and fired at him. The death was immediate out of grave provocation. The client was taken into custody and he was in police custody and thereafter judicial custody for about 1.5 months, after which bail was granted to him. He was a businessman. The trial went on. In 2005, he had approached me to defend him, which I did not do because I knew the case was not of much merit. But astonishingly, maybe because of the prayers that he had made, the client got acquitted. And what the order said was that the ballistic opinion in this case was that it is quite impossible that the bullet which has come out from the gun could have come out from that gun and could have pierced into the heart, into the chest of the victim. Now this kind of a opinion, which I may respectfully say that this cannot be a basis of an acquittal. You cannot have a very confirmed source of authenticity based on such opinions when they say that two opinions are possible. This is just not possible. An emphasis on this kind of a opinion by the court is always faulty. A second case which I would like to emphasize on, which I am handling and I'm appearing on behalf of the complainant, is the case where a a lad who was harassed by his wife, hanged himself. When he hanged himself, the opinion given was that of hanging. The postmortem report said death due to hanging. There ends the report of the postmortem, and there ends the medical report, which said that the death was due to hanging. Now, what happens and what is to be considered is as to whether this kind of a report would itself amount to a fact that the person would have committed suicide. Seeing the wall writings on the wall of the room in which that lad had committed suicide, the wall writing suggested that he had written something and he had committed suicide after writing this in his own blood, which he had put it on the Facebook also. Now, in such a case, the handwriting expert opinion who was called upon to see those handwritings and testify gives a report that it is cannot be said with a certainty that it is his handwriting. Now, how can one rely on such kind of an expert opinion? Sometimes the police, in hand in gloves with the complainant, with the victim, with the accused, destroys those particular records, and police investigation comes into question. Now, when certain paints on the wall or certain writings on the wall are destroyed with effect of water or certain things, how can the handwriting expert opinion ascertain that it is the same handwriting? It is not possible. So in such cases, handwriting expert opinions are discarded. Now let us come to a case where a false doctor's report could be exposed. There was a case which is still pending, even the previous case of the boy committing suicide. Even that is pending. The Supreme Court has taken into account our plea that police investigation can be challenged. It has been referred to a larger bench on 7th May 2018. Now coming to a second case which is also pending in High Court. A girl who had purportedly committed suicide. She was reported to have committed suicide after throwing herself from the third floor of the building, and she landed with a thud on her face. When the body was taken for post-mortem, the jewelry was found not there. The head and the skull should have been broken. That the doctor says that it has not broken because there is a shock. Upon examination of the body, there were marks on the hand as well as on the neck of the girl who was harassed for dowry and for various other purposes. A mark of fighting was found on the neck, on the hand, and on various other places. And there were scars. Now, in such a case, to say that the death has occurred because of the body being flung or the body of the lady committing suicide would be nothing but a farce. It would in fact question the ability of the medical opinion given by the doctor. And soon after the medical opinions are given, in many kind of sensational cases, the doctors are transferred. So in such cases, an expert opinion would matter little. The circumstances prevailing and all the other cogent evidence which are prevailing would definitely throw light upon these kind of cases where opinions are to be accepted or rejected. So an expert opinion would always and always depend upon the quality of the other witnesses. An expert opinion by itself cannot be a basis of convicting or acquitting any person. Now, in cases where expert opinion must be accepted, we'll take those cases. There was a murder case in which I'm appearing for a victim. That case is also attaining a lot of popularity over here in Bombay. A man was murdered at a place known as Dadar in Mumbai, a very densely populated place. The man was murdered because of an honor killing, because he had eloped with a girl from the village. The man was already married, so the brothers of the girl came and they killed this man in broad daylight. He was a juice seller. And when the man's body was taken for post-mortem, a serious case of killing was made out. Choppers were used, his neck was slit, and a medical report stated that yes, it is a killing and a murder. And finally which was actually a very abysmally poor show of the Sessions Court, based on a faulty test identification parade. The people were acquitted after 7 years because the evidence was not proper, only because the test identification parade was not done. So in such cases, the other evidences are discarded and expert opinion has to be used. Now, what happened when we went to High Court? In High Court, luckily there was a Supreme Court judgment to our aid, which says that only because of test identification, which is in short known as the TIP, is not done properly, it does not mean that the crime has not been committed. So in my arguments, I asked the judge, see, look at the medical report. In 24 hours, the body has been sent for autopsy, for post-mortem. And look what the report says. The report says shock, abrasions, as well as injury due to chopper and the weapon, the knife and everything has been recovered from the spot. So definitely it means that the person has been killed. So your expert opinion would definitely lead, a medical opinion would definitely lead to a conclusion. Then if a person has been killed and if it is not suicide, which means that the crime has occurred. So saying that only TIP is not proper in the light of expert evidence, expert medical evidence available, then in that case, the conviction of the person must be certain, and acquittal is acquittal is a very erroneous approach of the trial court. This is one way of saying. Now we come to some serious cases. Say case of a fudging of accounts. Let us see a case where the chartered accountants are involved in committing a crime. Being a CA turned lawyer myself, I did the audit of Bank of Karad, IndusInd Bank, and various other banks when I was in my articleship days from 1995 to 1998. In those days, I used to even audit Indian Petrochemicals Limited, Thermax, IndusInd Bank, and various other organizations. And in my audit, I was specifically given internal audit due to my skills of determining who has committed crime where. Now, what happens and how does expert opinion come into place in cases of money laundering? How does money laundering take place in the first place? Money laundering would take place in a number of ways. One easy example of money laundering is that money which is collected from unofficial sources is put into various accounts, income tax is paid on it, and after income tax is paid on it, that money which has come from unofficial sources comes into the wide circulation of money in the economy. When it comes into wide circulation of money in the economy, definitely you cannot trace it. And therein lies the fact as to how the money laundering has taken place. Money laundering has got 3 or 4 phases. One is the introduction phase, then is the layering phase where the money is circulated, and then is the filtration phase where it is mobilized. A lot of underworld money which has come into the film industry, a lot of underworld money, political money, money of corrupt officers which has come into the economy, has found its place in various streams. For instance, the construction industry, the film industry, and various industries. Now, how would a person determine as to how effectively this money laundering has taken place? This is done with the aid of specialized agencies which give expert opinion, which have got wings, which have got economic offenses wings, which have got chartered accountants, which have got certain kind of people who will determine as to how expert opinion would matter, and how that expert opinion is considered by the reporting officer into the court, and how the chartered accountant or how the analyst has analyzed it and placed it. These cases usually go on in special courts of the sessions or special court appointed under the special court bill. For instance, the Harshad Mehta scam. There, a team of chartered accountants. I think in Bombay we had Balsara and Company. Then we had a very famous team of chartered accountants, which studied this and which reported. I remember when I was doing this, my chartered accountancy, I had prepared a report on the Apple Mutual Fund, in which in the period of Harshad Mehta, we had pointed out as to how the prices of certain shares had been inflated. And within the scheme itself, they had 2 or 3 schemes. One is the gold scheme, the other is the platinum scheme, one is the silver scheme. And within the 3 schemes itself, they used to transfer the shares at one price to the other scheme, showing that the other scheme is performing very well, and that is how the people used to get a very wrong picture. These kind of reports usually are authentic. They are not opinions. They are basically on a logically derived conclusion. They have a conclusive aspect, And these aspects are and are to be considered positively by any court or any Kasi judicial authority. To pause here for a moment, Kasi judicial authorities in India sometimes do not adopt the Evidence Act, because in Kasi judicial authorities jurisdiction, sometimes analysis are required to be done. And those analyses are not expert opinions. They are logical conclusion. Though it is an expert opinion under section 45, they would call it an expert opinion, but that would be a generic term. It is actually an opinion given out of a logical analysis derived as a set of transactions as to what is money laundering, and whether a crime of forging the accounts or falsification of accounts under 477 or 477A of the Indian Penal Code has occurred or not occurred. This is what falsification of account, how it is proved. Now we will give an example. Take an example of Satyam Computers. The person was fudging the accounts for a number of years. I'll give you an example. Suppose a person has a lot of cash money income. Now this cash income he keeps on putting in his account. He shows this cash money as income, pays income tax on it. The income tax department is concerned with the income and not with anything, and they will charge the income tax. Finally, when they see on the liability side, they find that there are a number of fictitious people shown as creditors. Number of fictitious people shown as creditors. They are not shown as fictitious. They will be PAN account numbers. They will be having proper bank account numbers. They will also, on cross verification, be able to tell you. But when a cross verification is done by the income tax department or by the CBI sleuths or by the Interpol, what happens over here is, when we come across this kind of a transaction, we find that on the day when a certain amount of cash was deposited or a certain amount of transaction has been done, these transactions are not bound or not based or are not founded on any specific transactional entry corresponding on the same day, or there will be a very huge cash withdrawal on the same day which will not be explained. Under the Income Tax Act, we have section 69A, B, C, D, which can add back all this into the income based on the expertise used by the assessing officer. Now, again in income tax, we have certain cases where people undervalue the property. There, an opinion of an expert would matter, and would not only matter, an opinion of the valuation officer along with an architect would also matter in evaluating a particular property. In these kind of cases where market rates are available, standards ready reckoners are available, in these kind of cases, the opinion of the expert or the opinion of the assessing officer based on the opinion of the expert or on the circumstances of the case is usually to be taken as final. There cannot be two chances and two opinions on this. Now we will come to a case of money laundering on an international level. After the making of the Vodafone judgment, in which with our Supreme Court of India also attracted a lot of criticism by the legislature as well as by the tax fraternity as well as by the legal fraternity. What happened in Vodafone's case? Decided by the Supreme Court per Honorable Chief Justice Mr. S.H. Kapadia. He's no more now. Vodafone's case was a case where Vodafone India was a company floated in Cayman Island, a tax haven, and Vodafone basically was having a proper setup. It was a proper cellular company. Now, in such a case, what used to happen was, in Vodafone, they bought in shares in India, transferred the interest abroad, and took away the capital gains and paid zero tax. Now, this was Vodafone's genuine case, in which the Supreme Court held that mere transfer of interest in another country would not attract capital gains over here. Now, as a result of this, now coming into export opinion where we would come. As a result of this, when we analyze what is happening after the Vodafone judgment, in 2010, under the Congress regime, 2005 to 2010 to 2010 to 2014, without having any animosity against the Congress, I would rate them as the years where the country degraded economically because of a lot of money laundered money which came in from abroad, which were parked into Indian assets, Indian markets without paying a single penny of tax, due to which the prices of the things went skyrocketing. And expert opinions have been given by planning commissions, expert opinions have been given by economists, expert opinions have been given by chartered accountants to various wings of the organization, and they have been taken into account, after which the law of black money, the Black Money Act has been passed in India. What happened? We'll come to that now. As a result of the foreign disinvestment policy being eased, people took advantage of the Vodafone judgment. Double taxation avoidance agreements treaties, DTAAs, of various countries were examined by the people in India. I will give you one example. I will not name the company because it is improper for me to name a profile, though it is a matter of official record. X, a razor company, had assets worth 347 crore rupees in India. These assets were exchanged at a loss or at a very nominal profit in India from one company to another company. When these assets were in as a year, there was a set off. You get a set off. If there is a loss in a particular year and if there are profits in the next 7-8 years, you get a set off of one particular year in the next 8 assessment years. As a result of set off, there was nothing paid as income tax over here. A share transaction was entered in Spain between one company shareholding 99% and another company, the Indian company, and the shares were exchanged at a profit of about 100 to 200 crores. This again was done in Cayman Islands. This was again done in Malta in a series of 8 companies formed in a period of 6 months. And finally, the final shares were sold at 3,427 crores in Melbourne, in Australia, amongst the family members of a particular family of this razor company. Now, this kind of a transaction, if we see, is nothing but a way of cheating the Indian economy. How will one prove this now? The proof of this lies in the report, which will be prepared by either by the Interpol or by the Planning Commission or by the Ministry of Finance or by the CBI, if the case of money laundering can be registered. And this report will not be able to be prepared unless some chartered accountant or some very big CA firm like Price Waterhouse or Arthur Anderson or AF Ferguson and Company or any Indian chartered accountant company of authenticity. We had years ago, we had Balsara and Company in Bombay High Court. Some such company which has to prepare a report, and based on that report, a case of money laundering can be registered by these agencies. What happens? Do you think the real value of the 3,427 crores? It could be, if it is a genuine transaction. But it could also be that a lot of black money has gone by way of hawala to these particular places abroad, and a transaction is generated that it is a genuine transaction, and finally all this money which has attracted nil liability comes back into our country and it finds its way in the real estate towers, and we have a result of 5 lakh flats lying unsold in Mumbai, 3 or 4 lakh flats lying unsold in New Delhi, lakhs of flats and properties where prices have been charged at 13-14 crores, but not one genuine buyer in that building. It is actually a slap on our economy. And here is where a good expert's opinions report would really matter on the very mega scale. Now, this is where expert opinion, but what happens in practice? Section 2 and 3 of the Evidence Act gives a very, very quaint kind of an ambiguity. That ambiguity this Evidence Act may not be applicable to CASA judicial authorities. My question in turn to the Bombay High Court at that time was, then which act will we rely on? If Evidence Act is not available, Evidence Act is basically an act which is governing, it's an evidence law, though it is not as Evidence Act. It is evidence law. It is more like illustrative. No evidence law can be exhaustive. It all depends on various facts and circumstances of various cases. So you cannot have a straitjacket formula that yes, under this circumstances, eyewitness should be required as proper. Under this circumstances, handwriting should be recorded proper. These things cannot be held. So a basis for acceptance of a particular project, which is going on in urban cities like Bombay, where again expert opinions are given, debated, sometimes accepted by the court, sometimes not accepted by the court. The structural engineers report in the case of dilapidated buildings. I incurred a case in 2016 as and I was appointed as a lawyer for about 2,000 people. The police had come with a big lathi charge. They had asked them to vacate. There was a Supreme Court order, and the builder had given certain promises to the Municipal Corporation of Greater Bombay that he would be fulfilling certain criteria, 50 crore rupees deposit and various other bank guarantees to be given, which he had actually not provided. We challenged this in Bombay High Court, but the Supreme Court order had already taken its effect, and people had to be evacuated. When I studied the entire report of all the 15, 16 buildings at Tadwadi at Mazgaon, I found that 3 or 4 buildings were actually in proper inhabitable condition. There was nothing wrong. They were only old. And the structural audit report also was differing. So in these kind of cases, usually what the court sees is 70% majority, and structural engineers report on a large scale says this, and we give a go by. This would be a very, very dangerous way of admitting expert opinion. Courts, even Supreme Court of India, even Bombay High Courts have with greatest respect, have been totally erroneous, ridiculously erroneous to say the least. I'm really sorry I'm using this word. That this kind of a report is accepted, which would determine the lives of thousands. And finally, acceptance of this kind of a report, asking the people to evict, and those buildings are still standing over there. If the buildings are still standing over there, and if the report says that this was inhabitable and could fall any moment, then after evicting, how have these buildings stood for the last 4 years, and you have evicted them and kept them like animals in small places at Mahul? There's a place known as Mahul in Mumbai, where rehabilitated people are kept, and the project has not yet taken off. Come to a second case, where a very smart builder prevented a building to be demolished by way of using another technique. I will not name the builder because he has asked me not to name him. In Punjabi colony, in Sion, a place known as Sion Koliwada in Bombay, GTB Nagar, I was appointed for 8,000 people. I got a stay from the Supreme Court on a particular point. And in here also, there were 3 or 4 buildings which were in sound state. Of course, 60-70% were in some kind of a state which should not have been. But to say that the building could have fallen, and merely because a building requires some structural repairs, would not be a indication that the building could fall, and which would unnecessarily form a basis of evicting people and victimizing the people rather than providing them rehabilitation. It is being done at the behest of the private builder lobby, which wants only concrete jungle in Mumbai. No spaces left. The once good and beautiful Mumbai is actually, I would say, with humblest respects, though I'm born and brought up in Bombay, has been reduced to a concrete jungle. There are no spaces left. There are few spaces which are open air left in Bombay today. This is all a result of a faulty appreciation of opinions by the courts of law. Very few judges take the effort to come and witness what is actually happening in a particular place, or what is not happening in a particular place, before coming to a conclusion and jumping to a conclusion. These kind of expert opinions basically should not be done in a case. Now, what this builder did was, in order to save his building, he never wanted to redevelop the building. He wanted to repair the building and redevelop the next building. So the tenants had requested him not to demolish this building. He went to VGTI, another very prominent institute which can give structural report. He went and he got their report. He opposed the BMC report, saying that, look, this is also VGTI's report. Many of your engineers are working in VGTI, and how can you say that your report is proper? He filed a complaint on the municipal authorities. So one very weightful opinion against the other expert opinion prevented that demolition to take place. So these are places where expert opinions could be admitted, it could not be admitted. In certain cases, an expert opinion would be final. For example, I would comment on cases where people have died. When a person dies of renal failure in hospital, the doctor is treating him. The opinion is final, yes, he died due to renal failure because of asphyxiation as a result of raise in the potassium level, and he expired. He died of cardiac arrest because of this, or he died of a fall because of a shock on the brain. These cases, the evidence is conclusive. But to say that expert opinion would be the basis of any kind of conviction or the basis of any kind of acquittal, and as a straitjacket formula in all the cases, it is not possible. It is just not possible. Now, we will come to another aspect where law requires an expert opinion always, and that is not under section 45. That is under the law itself. For example, when a chartered accountant gives a report under section 44AB, the tax audit report upon whether the tax compliances have been done, he's actually giving nothing but an expert opinion. He's giving his opinion and he's certifying it. That is an opinion certified and labeled by law as necessary. An opinion given as to a particular infrastructure project, whether the money is being utilized for an infrastructure project or not, by the chartered accountant. It is expert opinion. It is expert opinion, though it can be recognized under section 45. Usually courts don't refer to it as section 45. Everything in law need not be codified. They go by the chartered accountant's report, and the report filed and accepted by the Department of Income Tax or other revenue authorities, whichever authority. Similarly, recently we had the Worli Ceiling project. The Bombay High Court came to a conclusion that a number of opinions given by the seismic authorities, a number of opinions given by the environmental authorities was improper, and the ceiling project was actually should not have gone through. These kind of opinions are analyzed by the court based on comparative studies, based on the tools and the tenets on which a case is used, and after which the courts come to a logical conclusion that due to these and these reasons we are placing reliance on expert opinion, and that is how an expert opinion is assimilated in these kind of cases. So over a period of time, in this last 45 minutes to 50 minutes which I have spoken, I have taken the pain and the effort to cover cases of economic significance, cases of tax significance, cases of criminal law significance of murder and suicide, cases of money laundering, cases of real estate developers. I think I should be concluding the argument because most of my points which I had to say have been covered, and I hope all of you all have liked my speech which I have given. And if anyone is there to question me or certain particular questions, if you all have, you all may be free to ask me. Please go ahead, sir. Hello. Hello. Hello, we have 10 minutes more. Hello. Hello, Mr. Admin.
Oh.
Hello.
Anyone having a question?
So, admin, did you appreciate the work, the work which has been given to you?
Yes, sir.
Okay. So shall
So
I?
by
Shall I?
conclude, okay,
Yeah,
sir.
yeah,
Yeah, sir. Please continue.
See, at the final stage, finally, I would like to tell everybody, while evaluating expert opinion, always see and test the circumstances whether it is required. Going to a court with an expert opinion when the facts are clear will only make a fool of an expert as well as the opinion. That is my own appreciation for the past 20 years. And sometimes when the courts really insist that what does the expert opinion say, then come forward with the expert opinion. Sometimes the facts may be so clear that an expert opinion is not required. And still people come out with expert opinions. The departments come out with expert opinions for what? So this is my final conclusion, that no expert opinion can be a standard formula. Yes, in certain cases where law mandates that a structural engineer's report is necessary, expert opinion required. A chartered accountant's report is necessary, expert opinion required. A ballistic report is necessary, expert opinion required. Environmental report, sound decibels, whether the sound decibels have crossed a particular limit or no, expert opinion required. But in cases where things are evident, and cases where witnesses and the circumstances are so strong that it shows, in that case the court, even if you produce an expert opinion, it is of not going to be of much use. That's all. Jai Hind. I love my India. God bless you.
Thank you, sir. So by concluding today's session of the International Law Conference, I want to thank to the speakers. Thank you, sir.
All right.